got the matter yesterday.
You have participated
And then now you are coming and telling. Have you got the judgments?
One
Yes.
judgment of our Honorable High Court. Again,
But what we are stuck up with the Supreme Court judgment. What to do, sir?
Against-
Supreme Court judgment is binding on us.
well, what I was submitting is this Honorable High Court has also passed judgment that after participation of the in the tender was precluded. But the one, with your Lordship permission, I'll not press that point. If your Lordship permission, one judgment I found out from Honorable Bombay High Court on this point. If your Lordship permits.
But when you have a 0 kilometer judgment, you have another 1600 kilometer judgment, then why you are
On identical facts.
whatever? Those are the judgment prior to Supreme Court. Give that judgment. You're citing, sir. This is not a judgment on this issue which we are. Sorry.
Paratel lordship. Next judgment, paratel lordship. They have lordship, right? And our own High Court judgment lordship. Paratel lordship. Paratel.
You are challenging that clause E is a IT return for last 3 assessment years.
Well, it's clause E would be the lottery clause that is in the
Which one? Because your prayer is very clumsy. That's why I'm asking.
Well, it's clause E.
Clause E is appearing at page 35.
Yes.
It says IT returns for last 3 assessment years.
It's clause E of page Malats at 41 if your lordship says.
That is a financial bet, but you have not said so.
Well, it's where
Shall we award it the contract? Yes. Where is the code? Where is the code? As per code means what?
it's as per code they have not prescribed in the entire tender that what is to the code. The code
There is a code that must be, there must be some statutory law.
WD will not.
This OPWD code
Not applicable here.
is
It's not applicable.
not applicable. But they have referred this as per code. That's why I'm asking, what is this code? Anyhow,
Appears in OPW code, lordship, this by of lottery, OPW code not applicable to the present
that's true.
tender, lordship. So the lottery is available there, lordship. 3.5, 5.5.
Look, Yes,
Without.
without. No cost. It's called the mix.
Item number 2.
Then here is
Which order?
order.
20th of June.
Yes, no.
Yes, can you give me 2 minutes time? Just take your seat. Let me hurriedly go through the order. Yes, sir. How can you be educated and unemployed? Being a proprietress of the concern, so you are a self-employed, not unemployed. Why you have used that expression in the pleading? You are running a business and unemployed.
Trying to
Self-employed.
thereafter run the business.
What?
Well, before application, I'm unemployed.
No, sir. You have floated a partnership concern.
Yes.
You are the proprietress of the partnership. Yes, sorry, proprietorship concern.
For this business, for getting the plot and carrying on the business.
Well, so the malafide intention is there that you wanted a plot.
Yes, for that reason only. ITCO supplies.
It is there, sir. Show cause notices were issued
I just
under the Public Premises Eviction of Unauthorized Occupants Act. The proceeding was initiated. You challenged that order before the appellate authority. And ultimately, by virtue of a clause of the lease, now they have forfeited the lease.
just bring to your lordship's few points, subject to your lordship's consideration. But after the lease was executed, I was given possession. I had to construct for construction.
True, you applied for a sanction plan or sanction of the,
Yes.
that was not done
No, no.
to approach the writ to court.
No, they said that you approach the video. The video is the only. So I approached the video. Video twice returned saying that you apply under this format, and I have applied. So therefore, the continuation was there, and it was without considering my application because ball is in their court. If they give the approval, I can go on with the construction.
No, approval, I do not know, but the proceeding was initiated under the public
Yes,
premises.
and in the
Now what to do? That culminated into an order of
the
eviction.
appellate court observes that, your lordship sees that appellate court's order.
No. It, after all, it did not set aside the the order of the state officer.
No, set aside means this is the authority. May I just replace?
I do not know. Odisha public premises eviction, I do not know. But Central Act, I know, public premises where the state officer is
Yes,
section 4, the opinion and the notice, and then adjudication, order under section 6, and then the appeal under section 9.
But first, your lordship, just one or two documents I'll show you for your lordship. That's
What would happen now? What troubles me is that what would happen to the judgment and order of the state officer?
Estate officer, we went up in appeal.
Correct.
And appeal, your lordship sees what is the order in the appeal. That is neither a dismissal nor some relief has been given to me that your lordship
Has the appellate authority affirmed the order of the state officer or
No.
reversed the order of the state?
modified. Page 82. Page 82, your lordship.
Yes. I give 82.
Page 80. After he discusses the facts of the case,
Yes.
lordship, in view of the
Enlarge it.
second last paragraph, in view
Uh,
In view of the facts discussed above, this court is inclined to hold that both parties have not taken any interest for setting up the interest. Well, hence, both parties are equally responsible for the same. Besides, the appellant has bought the plot on lease basis to maintain her livelihood by setting up a small-scale industry without cooperating the lessee to set up the factory, providing infrastructure facilities, issuance of eviction notice under so-and-so act, which is not good in the eyes of law. Hence, considering the prayer of the appellant, the court is of the opinion that due infrastructure facilities be provided to the appellant by the respondent, that is IDCO, for establishment of the appellant is.
then what happened thereafter?
No, thereafter nothing happened. I applied.
So literally the order of the state officer, a state officer, is put into a cold storage.
Court story. But appellate court says that.
Then can he proceed on the basis of that order?
That is what exactly I bring to your
What
knowledge.
is for the other side?
But it's coming for the first time.
Any caveat is lost? IDCO?
IDCO.
IDCO, where is the
No,
notice?
Notice has to go.
they don't appear.
This is because it says that the notice.
There
Issue notice.
IDCO council before the learned single.
to counsel, Mr. P.K. Mohan. But they have a panel of lawyers, I don't know. I'll take out notice. Permission.
Notice, there is a issue notice on ITCO. Ms. Patnaik appears for the state Mr. Mishra, have you gone through those provisions? You've seen that? What is your opinion in this regard?
But I think so far as the dispute we raises before the OC, I think it should be adjudicated in the High Court. That is exactly I feel. Everything that doesn't directly relates to grant delay. Therefore, it cannot come within the purview of section 24B to refer the matter to the tribunal for adjudication. That is my prime view after I have gone through the statutory provision and all that.
What?
But one of the decision also to that effect is there.
Where is which act is under consideration?
If your worship looks at, here is a case, my his physics department, he was initially appointed as a demonstrator, he was claiming to be the lecturer in fact. His promotion is dispute with regard to the selection process. But that is the reason why you wanted to know, the honorable single judge has held that since the director has rejected his application, he should approach the tribunal again
Correct.
instead of coming to the High Court.
Correct.
The Honorable High Court has said, no, you approach the alternative forum.
Correct. Correct.
So here it may not be required, in fact.
So that is what I really wanted, because he was referring some certain provisions. That's why we invited your good office
Well, in fact,
and your wisdom to
so if you are
assist the court
24B
of
of the Education Act, Orissa Education Act,
1969.
1969.
section 24,
Capital B.
capital B. Yes,
May I just read it, Lord?
yes,
The tribunal shall have jurisdiction, power and authority to adjudicate all disputes and differences between the managing committee or, as the case may be, the governing body of the private educational institution and any teacher or employee of such institution or the state government or any officer or authority of the state government relating to, here actually the catch
that is
there,
what, yes.
relating to or connected with the eligibility, entitlement, payment or non-payment of granted aid.
So that's why I was just thinking about the three categories when the comma or the punctuation is used. First is the eligibility. Second is the entitlement.
Right.
And the third one is a payment or non-payment of granting aid.
Right.
So this is a combined category. Payment or non-payment relating to granting aid.
Granted.
Nothing relating to
Any other dispute.
any other disputes.
That is exactly.
So now question is the eligibility, because he was asking that I was demonstrator, I was promoted as a lecturer, I cannot be kept as a demonstrator when I have already been appointed as a lecturer. They have not approved it.
Right.
That means the eligibility to have the post of a lecturer or entitlement to the post of a lecturer. So if that being the position, I was thinking
Tribunal.
trouble.
Well, here actually, let me clarify. Eligibility for granting aid.
Yes, sir.
That was the argument which was advanced, that eligibility or the entitlement
Yes.
are really
To the
prefixed with the granting aid.
Correct.
But there is no word in between, punctuation in between payment or non-payment.
Now here the only thing is the comma or any
Because I was thinking that this granting aid is a genus which includes payment and non-payment only.
with due respect, what I feel, payment and non-payment of granted aid cannot be segregated from the previous sentence because of the word issues generis manner. It must
Adjustum generis, I understand, but The punctuation creates a
The punctuation-
confusion in my mind.
Punctuation sometimes lead to an inference, but punctuation cannot itself be a decisive factor. And the Supreme Court has said, your lordship referred to your lordship decision 2011. That order 43, rule 1,
Or
whether the independent appeal is to be filed or
Correct.
2 appeals to be filed.
Yes.
Your lordship held specifically that 1 appeal is maintainable. That judgment, I think.
Yes, yes, that is there. That
is
is
there.
there.
So those punctuation of comma and all those things cannot lead us to a different proposition altogether when the intention of the legislation is one. But this provision has been incorporated, if I rightly recollect, to minimize the disputes of granting it pending for the High Court, so that that can go to the tribunal for adjudication. Even anything relating to or connected with the granting it can be referred to the tribunal. But here, I don't think he claims granting it for that purpose. But a simple dispute with regard to the eligibility of promotion to the post may not come directly under this provision. There is a division bench decision, though they have not analyzed it vividly. But you kindly take note of. I have tried to locate it, in fact. Yeah.
Taken up another issue in support of your contention.
Yeah.
If you take that section 24B again,
No.
we have read subsection 1. Subsection 2 talks about the application to be made by an aggrieved person. It says make an application for redressal of his grievance.
Yeah.
Application. Then come to 3, says that if on receipt of an application under subsection 2, the tribunal will satisfy itself, then he is taking lead of the proviso.
Yes.
He
Provided-
says that the proviso makes it more clear it is grant in aid only.
Right.
So he says that provided no application, means on any ground, whatever, which are contemplated under subsection 1, seeking a claim of grant in aid, it says.
Right.
So if it is a grant in aid is the main issue,
Yes.
then entitlement and the everything is to be attached with the grant in aid.
Correct.
That is what he wanted to say.
The whole section has to be read as a composite one.
So it
All-
is,
all
what you say is that it is all relatable to a grant in aid.
Your Lordship, my humble submission is that the issue relating to payment, eligibility, entitlement, payment and non-payment of granting aid in relation to the post of demonstrator to which I was initially appointed and to the post of lecturer to which I was elevated was.
You see, they are also talking in that sense that whether these kind of a things where the entitlement or the eligibility to have that particular the scale of pay is relatable to a grant in aid.
He says it's not connected.
That is already decided, Your Lordship.
What?
In case of this post of demonstrator as well as in case of the post of.
Then why you are approaching the court? So the difficulty with this, I have not, because I have requested him just on a proposition of law to assist the court, which is within the judicial system, that the judge may request any of the senior counsel to assist as an amicus curiae. So he is simply assisting, he is not arguing your case, he is simply assisting the court that what should be the correct law which the court should decide.
Irrespective of the distance.
Irrespective of the facts, because there will be another question that would come to you. Don't worry. Even if we are more on this issue, whether the tribunal, and if tribunal, then under what category of the cases should go to the tribunal and what should not. We are more on a basic fundamentals than on the merit. Because it has a larger impact, because everybody then has to follow that. It's the division bench judgment.
So kindly look at the division bench judgment. I've given it first. Just for a second.
Grant in aid is defined in the act.
Yes,
No.
yes.
Or what?
13 is there.
7C. 7C of the Act.
No, I'm talking about the definition clause. It is not defined.
It's not defined.
Granted. Now,
7C, if your lordship may.
7C.
7C. 7C 4 would make it clear now. It is not only the institution but also the post.
Yes, salary also.
Yes.
So really grant in aid is attached to
It
the
runs
salary.
concurrently, my lord. Everything
Correct.
runs concurrently.
Correct. Yes, 4. Subsection 4 is very clear. Because 1, 2, 3 was conveying a different intention.
Not
That
a
is,
person.
4 is also there. Subsection 4.
Yes.
To any person employed in such for any post or to any person employed in such institution. So although the word or has been used, but it has to be read as if the person holding the post and
Post or to any
and
person
getting
employed.
eligible to get the grant.
Yes.
And what is the claim of the petitioner?
That is on merits.
I'll-
We are
I'm
more
sorry.
on a basic question.
Go later on.
So we have really given a trouble to Mr. Mishro. Just to have, because the concept, the understanding of the notion in my mind was in relation to some other state law, that the grant in aid is only for the purpose of encouraging the private educational institutions, because the government cannot establish the educational institution in every nook and corner of the state or the country. So there were many private organizations, they were establishing these educational institutions and they were running it. Now, because of the paucity of the funds, some of them were really in, I would say, in a bad financial shape, and were going to close down, just to give an impetus so that there are large number of the students, or there are large number of the children who are really benefited by that. Then the government says, I will give you a lump sum grant. So sometimes it is called an aided school, sometimes it's called a non-aided school. There the words are the aided school and the non-aided school. Aid means the government is giving an aid to them. So if you are receiving an aid, then you are considered as an aided school. The same thing is a grant in aid. So just to give them some kind of a support.
Financial support.
financial support. And then the government retains certain controls over them, because once they give a financial support, they are entitled to
Have some control.
yes, control, and the accountability is there that how you are spending the money. So this grant in aid is also in relation to, it was in relation to an institution. How that money is to be utilized is within the institution.
So the guideline has been fixed, Madam.
It may be utilized, for the purpose of, the meeting out the infrastructural, the development. It may be used for the purpose of payment of the salaries. It may be used for the purpose of meeting the other daily expenditures. So it all depends that how that money is utilized. So it is, I was under the impression that it is really given to an institution, not to the individuals. I was thinking of the individuals,
So here,
whether there is an individual's right to have a grant in aid. That was really going in my mind. But
7(4)(c) is clear.
And the cabinet memorandum that the object behind incorporating this 24B. the Lordship
That is what you
last
also
occasion
wanted.
wanted.
yes,
Lordship may kindly have.
But the debate that was made to incorporate this function.
well, that would throw light in this regard.
I think the second paragraph has made it clear.
Oh, because the first line was what I have a notion. It says, though there is a provision in the Act for providing grant in aid to eligible non-government educational institutions. Then it says the primary duty and the responsibility lies with the managing committee / the governing body to bear and pay the salary cost of the teachers. The economic, the liability of the state government is limited to its economic capacity and to the amount set apart annually for the purpose in the budget. The liability of grant in aid, I do not know what is this, liability or what? Liability of grant in aid on account of career advancement is also limited to this. Can't read.
Very old.
I think some black, it's blackened. Give it to him. Give it to him. Give it to him, Mr. Mistry. Second paragraph.
Oh. Limited to the adjustment.
This blackening has really created, I can't read that.
The original page was folded.
That is what it appears.
The photography was taken, so the line is there over it. It has become dark.
So that, Mr. Das, it is, the bill is not there. No,
No,
you
amendment
have
bill-
said, no, you have said it is financial memorandum. But is there no bill?
That is the object behind bringing this amendment.
No, no.
Bill will be accompanied with
Bill-
that.
No, no.
Bill is also gazetted certain times.
No, that does
Along with bill, statement of objection is.
not contain the date.
No, statement of objection is also, so it would be enclosed with the bill.
Bill, that would remain with the.
So. And notes and clauses, that will also go light when it is introduced in the assembly.
Anyhow,
notes and clauses, this financial memorandum, and another document that is called statement of objects and reasons.
But I think this is the bill.
This
Actually, the last paragraph, it says, thousands of cases are being filed. That is a kind remark. Thousands of cases are being filed before the Honorable High Court, invoking its extraordinary jurisdiction in the matter of payment of grant in aid by teachers of private educational institutions. This has resulted in total administrative dislocation in the educational department, as it is impossible to handle such large number of cases at the level of directorate or the government. Besides, the burden arises is to put a lot of strain on the availability of time of Honorable High Court. In this context, it would be appropriate to enlarge the jurisdiction of educational tribunal constituted under this section.
Yes, I got it. Because we may be arguing on merit, but we can't enter into the merit because the single bench has simply says that you go there.
Go to the tribunal.
And if we held after this that no, is a writ which is maintainable, then the single bench has to apply its mind on the merit. So we have to return to the single bench to decide the matter. That is what I was thinking. And
very clear. Very clear. Statement of objects and reasons.
oh, this paragraph 2 is reflected very nice. Why you are not referring this? This was,
Financial memorandum is.
Paragraph 2.
yes. Since it is not possible on the part of the state to bear all liabilities beyond the amount set apart annually in the budget for the purpose of granting aid, it is necessary that the duty, responsibilities, and liabilities of the non-government educational institution on this score be specifically provided.
Yes.
That is what is paragraph 2.
Paragraph 2 of that.
And then it says thousands of cases are being filed.
So this is statement for objects and reasons.
Yes.
There is a member in charge who has introduced that particular amendment bill. He has narrated this, that why I'm introducing this. Yes, I got it. Yes, we will not enter into the merit because the single bench has not gone into the merit of the case. Simply has relegated you to the educational tribunal. So let us decide the matter. And if we find that no, your writ petition is maintainable, then we are sending it back to decide on merit.
But you not said there is the Roma Shankar versus Madhya Pradesh State Public Service Commission. There in Paras 3, it has been held that the division bench needs to consider the appeals on merits by deciding on the correct.
True, when the single bench has decided the matter on merit, then the division bench definitely has to decide the matter on merit. But the single bench has not decided the matter on merit. Actually, simply says that you have to approach the tribunal, you go there. So if we held that no, your writ petition is maintainable, you are not supposed to go to the tribunal, then it is the duty of the single bench to decide the matter on merit. And once he decides the matter on merit, and if the appeal comes, then it is the duty of the appellate court also to decide the matter on merit. But merit has not been gone into.
So kind of look at the
So-
division bench decision.
That is my view is that
Yes.
if we decide the merit, you will be losing one forum or they will be losing one forum. Suppose we decide against you, then you are losing a forum. Then you'll have to go to Supreme Court. If we decide against them, then they are also losing a forum. So if the single bench decide, at least both of you have a forum to come to a division bench.
Again,
So that is what we want.
the paragraph.
Yes, thank you.
10 of the division bench decision.
I've seen that. But it has not gone into so
Yes.
deep into the aspect. And I have seen that. I was reading it,
No.
and simply on a superficial manner it has been done.
That's exactly it. But sir, other decision, I think you must have seen that. That 2008 Orissa, I don't think that is correct. But what I feel, but it's also side. Paragraph 15, they have been indicated. Last date, you must have seen that judgment.
Yes.
The 2008 Orissa case 5-6,
Yes. I still remember.
paragraph 15.
Case of state of Odisha versus Anup Kumar Senapati. That is
Yes.
the Supreme Court in para 23 have observed, has interpreted this 7C. Although it is a case of granting it under a repealed statute, whether one is entitled or not. But 7C, which your lordship may kindly have, I have another copy. Writing another. Para 23, if your lordship that is.
Paragraph 2.
Yeah.
In paragraph 23. It's just quoted that.
But they have, in fact, observed.
That supports your contention in one sentence of the Supreme Court in this particular Anup Kumar Senapati. It says that an application for receiving the grant in aid has to be dealt with considering the various factors as enumerated in 1994 order. That is, the post has to be filled up continuously for qualifying period of 5 years, 3 years, as the case may be. Employees to have qualification and experience.
And that judgment also decides, my lord. Once this 1994 grant in aid order is repealed by 2004 grant in aid order, the issue was before the Honorable Apex Court whether under a repealed statute, even if somebody's application towards eligibility is pending with the authority, whether same can be considered under the repealed statute. The Honorable Court said no. If it requires,
It's actually a beneficial scheme,
Yes.
or it is, so it cannot
And the
be.
matter of right.
Yes, nobody. It's not a vested right.
But your lordship, there is another subsequent order of this honorable court. That is the judgment dated 19th.
Sir, we have already, the difficulty is another. That once you have approached the tribunal also, can you bypass and then approach the straight away the High Court? We are not entering into those. The conduct may be a relevant factor for exercise of this particular discretionary power. We are not going into that. We are simply deciding so that it will foreclose those doors.
Right.
Paragraph 3 of the Lord signatures is.
Yes, we'll pass an order. If we dictate, it will take time.
Sure.
So we'll pass an order. Keep this matter in the next week on Thursday.
Outline of the case in one page. I'm just giving that one page to your lordship. Once you see that. Once you see that one page, these are requests for proposal or tender call notices which are issued by various district and state sub-regional headquarters hospitals for outsourcing of diet services, given that in serial number 1. This particular RFP was floated by the opposite part number 1, this deals with the Sai Institute of Medical Sciences. These tenders are fixed cost there. There is no financial proposal inside because the state government fixes the cost with regard to the food items. The tendering authority in all the districts headquarters are bound by the guidelines which is issued by the Family and Health Welfare Department, which is OP number 2. And the diet rates are modified from time to time by revised resolutions.
In this case, the petitioner has not participated. After the previous meeting, it raised its objection with regard to the non-adherence to the guidelines, and thereafter I have opposed this on the report.
You are challenging on the ground of a level playing field.
Yes, the clauses which have been
You
incorporated.
say is that that is a tailored made. I have already dictated.
Yes, my lords. As that-
Now you have highlighted that you have not participated.
Yes. And I stand on a much, much better footing because I have those government resolutions and guidelines to my.
Where is that clause 3.2?
That may I be to proceed with starting with the guidelines, if the lordship permits me. Starting with the guidelines of the government, may I start with that, if the lordship permits me. The lordship comes to page 61. I'll take your lordship chronologically, so it will be convenient for your lordship.
Give it page 61.
Page 61.
Yes.
Your lordship sees this is a notification with regard to guidelines to govern these kind of the subject guidelines for hospital guide revised heading. This is dated 22/2/2021. And if your lordship comes to page 63 where it starts. Then your lordship comes to page 67. Lordship has 67.
Mhm. Yes.
67 lordship sees 2.2 eligibility criteria, clause 1 and Roman clause 1 and 5. One says with regard to the bidders, and Roman 5 says for DHH and SDH, the bidder applying for DHH and SDH must have minimum average turnover of rupees 1 crore. Now this 1 crore was there in 2021 as per the then notification. Now your lordship comes to page 69. 68 also your lordship, also since your lordship is there, your lordship may have the look at that small bracket at the bottom. 68. Note. 68. Lordship has a small bracket towards the bottom.
ISO certification of food license.
No, just above 2.4. There's a note.
Yes.
There is no financial proposal to submit in the bid, and this is a fixed cost bid based. Then your lordship comes to page 69.
Yes.
Lordship sees the performance 4.3 is the performance security. This and 4.1 at the top. B, the contract shall be signed initially for a period of 1 year, which will be extended for another year if performance age is found satisfactory as per due assessment. 4.3 says secretary agency has to furnish the performance security of time of signing of contract to 5% of the total estimated cost, and so and so. Now your lordship comes to page 70. At the bottom, serial number 2, annual average turnover. Now this, your lordship sees, this was
Awarding of marks.
Yes, annual average turnover marks allotment. This guideline was issued in 2021. So accordingly, the price was then 1 crore. Your lordship sees below 1 crore. Your lordship may just keep an eye on the ratio, how they are fixing up the entire thing. Rupees 1 crore is 0. Rupees 1 crore to 2 crores is 10 marks, and rupees 2 crores to 20 marks. Now your lordship comes to the new tender notice. Your lordship comes to page 18, which starts at page 18.
80.
18, 1 8. NIT details are at page 90. Thereafter, your lordship comes to page 21.
Yes.
Your lordship sees the eligibility 2.2. Roman 4 and Roman 8 are my bone of contention, my lords. Bidder applying for themselves so and so, minimum average annual turnover of 9 crores per year during the so and so. And the clause number 8 says income tax return 9 crores. Now, if your lordship comes to page 27.
Yes.
Your lordship, just take notice of this. 3.2, category of diet and services. This is the resolution I am referring to. They are going by serial number 1, general diet 110. Your lordship, just keep this in mind. Since your lordship is passing through the pages, I just want to keep your lordship's notice to this. Then your lordship comes to page 50. Serial number 2.
Nine crores.
9 crores, 0. 9 crores to 18 crores, 10 marks. Above 18 crores, 8. That is my case, your lordship. This classification is bad. Now, what I did immediately, your lordship comes to page 73. I raised my objection. Since the government guidelines is that you could not have fixed it at so high a turnover clause. This is my formal objection at page 73.
Yes.
Then your lordship comes to page 75. This happened during the pre-bid meeting.
Okay.
We normally have a pre-bid meeting. On that day, I immediately objected to them, and they thereafter uploaded on your lordship. See the date at the top, 2/7/2025. They provided this proceeding of those pre-bid meetings. Your lordship, see the leads may I and enclosing here with
Yes.
proceeding of
Uploaded. Then
your lordship comes to page 77. Serial number 4. The committee clarified the aspirant bidders that the minimum turnover of ₹9 crore and has above been taken into consideration at the
so
average.
according to you, if the number of the beds and the entire year is taken into consideration, it is 4 crore 55 lakhs.
4.5 crores.
Yes, 4.
That means they should have fixed it to 4.5 crore, 4.54 to 9 crores. That would have been 20 marks. And to add, in fact, I'll come to that. The lordship sees that what they've done, they have admitted indirectly that the actual annual turnover is 4.5 lakhs. Now, what they did, lordship comes to page 80.
Yes, that's continuation of.
Yes.
That's the continuation of.
They gave a finding that going all through all details stated, third subpara, going through all the details stated by the aspirant bidders, the committee decided not to modify the clause so and so. Now I have immediately represented on page 61.
61 back.
I'm sorry, man, 81. 81.
Yes.
In fact, to be more precise, at page 82. Serial number 5. I made the submissions. I said the calculation, if issued as per point number 4, if it's calculated on average, the turnover is, in fact, brings up the incorrectness of the RPF dated so and so. Both serial number 2 with clause 5.2 and clause so and so of clause 4 and 8 of the clause 2.2. And I have given my detailed reasoning. Thereafter, your lordship comes to the next page. Just beneath para 6, I have given my calculation to them. That this should, if as per your calculation, if it's 4.5 crores annual turnover, then it will be 9 crores will be the outer limit. And if your lordship see, these are all fixed cost-based tenders. And to fix a outline of 18, 19 crores is taking away the rights of the regular participants who are participating in these tenders. So this representation was not considered. In fact, I pointed them out that this could not have been so. And if my entire case before them gets credence from the fact that if your lordship comes to page 47.
Earlier tender.
No, this tender. It starts annexure 2. This is that particularly I'm placing for 4.3 if your lordship sees.
47.
Yes, page 47, clause 4.3. While arbitrarily fixing that outer limit and the turnover, this remained as such.
5%.
Yes, if your lordship calculates 5% of 4.5 crores comes to this. And that apart, what they're trying to do in the counter affidavit, what they've done, my lords. Your lordship. In fact, at para 6, page 5 of the counter affidavit, the lordship has the counter affidavit.
Preliminary counter affidavit.
The flag 10, it's there.
Yes.
Para 6, what they do, they try to justify. After stating the reason, it is also necessary to state that lordship has para 6. Therefore, it has been decided to select one experienced with financially sound firm who can supply diet to the patients for 2 to 3 months without payment. Now, my case is, I have replied in my rejoinder that clause 4.5C of the RPF categorically states with regard to payment monthly payment of the bidder whoever is successful. Now, this is just an afterthought to justify. Now, second, they fall back on a final lordship sees para 7 just beneath that. They are relying upon a memorandum issued by the finance department, which they have annexed as annexure A by 1. The lordship comes to that heading of that annexure A by 1, guidelines which is starts at page 10, their internal page 10 of its memorandum.
Consultants.
Guidelines for consultants. And that if the lordship comes to page.
But also the outsourcing of services.
Yes, that is 16 page, your lordship. 16 outsourcing of other services. This outsourcing of diet services is not there. And that apart, if your lordship says this memorandum is of the year 2018, thereafter this guideline which I showed to your lordship under annexure 3, that was issued in 2021. Family welfare, health and family welfare department, they have come up with a specific, for these kind of outsourcing of diet, they have come up with a specific guideline. This is merely an afterthought assigning of a new reason by way of an affidavit that this memorandum governs us. Now, thereafter also even, they have relied on a judgment of this honorable court, wherein they have annexed that judgment, in fact. It's B by 1, wherein in a case of 2000, I think it was in the year 2000, prior to coming into this guideline, that
2020.
Yes, and that in that case also I had participated and thereafter challenged. That is at para 17, page 39 of that counter affidavit.
Para
17. So this case which I are relying upon, that doesn't apply to this case. Clearly mentioned, cannot turn around and challenge. Model principle applies here. I am not no way connected with this matter. And last but not the least, their own conduct. In fact, I have filed a memo, which is on your lordship's record, which I subsequently brought it by way of an affidavit also. Flag 30. The memo is there, and also subsequent affidavit which I brought it the same document on record by way of an affidavit. If your lordship has flag 30 for the reference purpose, at least at this moment. Lordship sees, the lordship has flag 30. Lordship sees the first page. This was the case of same hospital, 16/12/2022. Now there what they have done, your lordship comes to second page, page 2. Roman 4, your lordship may see. They fixed it at 6 crores. Then your lordship comes to
where?
page 2.2 eligibility criteria.
Yes.
Roman
4.
Yes. Bidder applying so and so.
6 crores.
6 crores. Now there similarly in the calculation column, your lordship comes to page 4.
Yes.
Your Lordship sees,
6 crores.
yes, 6 crore,
Then
thereafter then-
division is in 5
yes,
parameters.
yes, right. Then what they did, Your Lordship comes to page 5. They issued a collegium. They amended since the payment objection to that, they immediately went back on that. And Your Lordship comes to page 5. Serial number 3.
Now they have reduced it to 3 crore.
They reduced it to, this is the previous tender. I'm referring just for the purpose of reference, how they are doing it. Every time they're fixing up arbitrarily, thereafter they issue a collegium. This time they have not done that. Last page also eligibility criteria, they 2.2 page 6.
6.
They brought it down from 6 to 3. And the mark section, calculation mark section, which is the evaluation section, which is the last page, page 7 of that memo.
Yes, 3.
3 and 6 crores 20 months. So what I'm saying is in this case, if the annual turnover is 4.5 lakhs, if 4.5 crores, then the annual turnover in the first clause has to be 4.5 crores. And accordingly 4.5 to 9 crores, 20 marks for 20 marks. So that they have not done. It's a clear case where they are fixing up arbitrarily. And to support my case, I have two judgment of the Honorable Supreme Court. Which was gender conditions, level playing field.
Yes.
Reliance energy case, your Lordship must be aware.
Yes.
Your Lordship comes to the flat mark, flat 1.
Paragraph.
The paragraph is given 36 to 39, which is at page 21 to 23. Page 21 and 36.
Yes.
Thereafter, I have glad upon. This is a very rare case where the eligibility criteria is being tinkered with by the authorities in a very inconsistent manner, contrary to the guidelines and the resolution.
Yes.
Your Lordship, I have relied upon two High Court judgments for Your Lordship's kind consideration for reference value. Norms tailor-made, that concept. Flag 2, I have given water-based products, which is
A paragraph.
my lord's paragraph, para 8 to 10, there are, I've given the paragraph para 8 to 10 and 15, 16, 21 and 22. The relevant part is at 21. Use of the word assumption, like that in this instant case, they're trying to say that we may not be able to pay. That you cannot because you're entering a contract. So the case where eligibility criteria was fixed as such, similar to this one. Confirmation of the CEC guidelines.
Yes.
And the flag 3, another High Court, MP High Court judgment I've given. And with this.
Yes. Paragraph 22.
Yes. And the next point is arbitrariness. I think it's one of the recent judgments of the Honorable Supreme Court, where they have dealt extensively with regard to arbitrariness in contractual matter. Though this was pertaining to a matter where tender was cancelled, but the Honorable Supreme Court.
This I refer to them. The Subodh Kumar Rathore judge.
They have extensively dealt with the arbitrariness part. And para 60, they have given the relevant paragraphs. Para 65 is very relevant. Para 69, para 124. And if your Lordship has the note which I have given, second page, I've just, since your Lordship is aware of I've just quoted the relevant paragraph stating that they cannot assign new reasons by way of an affidavit. Memorandum, all these are afterthought because the family welfare resolutions and guidelines govern them.
Yes.
Point number C in my note, which I've given. Extracted knowing we will get.
Yes.
We cannot assign new details on the affidavit.
Can we have, so far as the duration of this tender is concerned, is 2 years. It's 2 years. Then the Lordship will look at page 76, that is the proceedings of the pre-bid meeting, where the petitioner as well as some other bidders, intending bidders, they had submitted their objections. Lordship may kindly see, my learned friend only pressed paragraph 4. Lordship may kindly see 4. Page 77. The turnover. The committee clarified the aspirant bidders that the minimum turnover of ₹9 crore and above has been taken into consideration as the average annual turnover of the tender call notice. There will be ₹110 per day, general diet.
Where?
If your Lordship, looking at page 77,
Yes.
internal page 2 of the proceedings.
Correct. The number of 9 crores and above has been taken into consideration as the average turnover is 4 crore 55 lakhs.
4 crore, they have given the calculation with 11 1134 beds, 365 days. It is
It's a contract for a period of 1 year,
2 years.
extendable for another year,
Yes,
subject to the satisfaction.
yes.
So you can't club it together. It will be a contract for 1 year.
And the condition stipulated in the tender document, your lordship may kindly see, it says the engagement shall be maximum for a period of 2 years from this date of signing of the contract. That is what
Where is that?
that is at page 47. Your lordship may kindly see. Page 47.
Yes.
Terms and conditions. Section
It
4.
is maximum period of,
The engagement shall be maximum for a period of 2 years from the.
that
signing
is the
of
outer limit, that only one extension.
Yes.
But look at clause B.
The contract shall be signed initially for a period of 1 year, which may be extended for another year if performance of the agency is found satisfactory. as
So
per
the
the-
certainty is of 1 year,
Yes,
but second year is the dependent one.
dependent one. And the
So
reason,
it will be a 1 year contract,
yes,
liable to be extended for another
for
year.
another year, subject to the subject to condition that it is found satisfactory on the basis of performance. If your lordship again come to that page 77, that 4 turnover I was placing, just below that the reason has been given why it has been done. The committee clarified that the aspirant bidders that as the Bhimsar Burla is an 1134 bedded referral hospital, it has been decided to select one experienced and financially sound firm who can supply diet to the patients for 2 to 3 months without any payment in emergency.
That is to
not
that he
available
reacted that actually the payments under the contract is every month.
every month.
So
But-
that means the authorities while taking the committee while taking a decision was of the view, yes, definitely the government moves in a slow pace. Payments may not be done in one month. So it will be a 2 or 3 months. Sometimes the payments are made.
So
So
that is
that
why-
is,
that is the
they have
financial viability
impliedly
of the-
accepted the government's functioning,
Yes.
putting a big question mark.
They have only said that since there occurs delay, so there should not be any kind of, uh, break in the supply of the item, because mostly the end users are the patients who will get the benefit. So to to keep that continuity, so they decided that a financially viable bidder should be selected in view of that condition, and that is why they have put that 9 crores as the minimum financial viability of a person, of a bidder concerned matter. And so far as the affidavit is concerned, we have not tried to improve anything on the affidavit. Rather, the decision which has been taken in the proceeding has only been reflected there. It is not that my land friend only pressed that paragraph 4. He didn't press the paragraph below, where the committee has expressed what is the reason for which they have fixed. And that certainly cannot be termed as arbitrary. But the decision may be, one may say that the decision is not correct for XYZ reason, but that decision is not arbitrary. And if your lordship will look at.
So he has said that in an earlier occasions, there was no difficulty, 6 crore was fixed. Later on, it was reduced to 3 crores. Everything depending upon that the situation is. So all these things are to be taken into consideration in that aspect. You have said that 4.5, there you can definitely put, you are simply looking at these economic solvency, or I say the financial solvency of a bidder.
Yes.
But you cannot take into consideration your lapses, your gaps, your inability as a benchmark for deciding the same. Can you? If the contract provides that the payment would be released on a monthly basis, can you take a parameter which is just, I think, that done away with your own terms and conditions?
I have only tried to address the, I mean, the practical side of.
Only thing is that it should be an uninterrupted supply because the patients cannot wait.
That is the only reason.
Under what reason? That he has that particular, the running the capital to provide the food to all these patients. At least I can understand for a month or a two. So you have taken a benchmark of 1 year. That is, sorry, he says that a benchmark of 1 year has to be taken. That I have the financial solvency to run for a year because I have completed the turnover. And there was nothing. Even if you take it as a 2 to 3, what is the rationale? Why not 4.5 when you have already taken in an earlier occasion?
But even if it is for 1 year also.
4.5?
But even if it is for 1 year also.
Correct.
This situation.
For 4.5, he says 4.5, less than 4.5, 0 marks. More than 4.5 to 6 or whatever is a 10 marks. And above to 9, 15 marks. And above 9 crores, give her 20 marks. Whoever is there in a level playing field, give him.
Now the situation is almost, except the petitioner, other bidders have participated and the technical bid has been opened, but it has not been finalized. This is the situation.
The difficulty is that you will have to, because you did not permit them to participate.
But in fact,
You have not opened the financial bid now. So nobody knows.
Here only the technical bid. Here only the technical bid there. There is no financial.
Because the benchmark is, because you have already fixed a rate. They cannot go to meet. They cannot go to reduce or enhance. They have to provide the food for this fixed amount, fixed price. Only thing is, who is more solvent, who is less solvent. There is no concept of a financial bid to be open. You have evaluated them on a technical aspect, awarding the marks, that's enough. What financial bid will do? Only declaration of the marks which he obtained at the technical bid stage, nothing more than that. Who has obtained more marks, we awarded.
Here there is no financial bid. It is only the.
There is no question.
Yes.
Because there is a fixed price. Only thing is, in a financial bid stage, you will just declare the marks. In an evaluation at the technical stage, you have awarded the marks on the basis of the papers or the documents which the intending bidder has submitted. Whether the documents are proper, verified everything you have done, and then awarded the marks. You will declare it at the financial bid marks that you have secured 80, you have secured 60, you have secured 50, you have secured. That's all. And now he is the highest bidder, secured 80.
The 4-1 judgment of Master Narayan. Direct 12 of judgment.
Citation, give it to him. 2005, volume 6, SSC 13.
1-3. Direct 12.
Oh, who disputes it? Who disputes it? But this is what a case of the apparent case of arbitrariness is an apparent case of the the unreasonableness. What more? And this is also said definitely. But Nesbari's principle is really a principle of reasonableness.
Decide whether our decision is arbitrary or not. That will be only.
What he says is that in an earlier occasion, realizing that what should be the cost, the decision was taken. In this case, how can you take a benchmark of 2 years when 1 year is the criteria, because it will be executed for 1 year, extendable subject to certain conditions. So it is not a inchoate right. The discretion is left to you. You may or may not extend. Can you extend if the performance is not satisfactory? You can't.
That we can.
But you cannot do it within 1 year. 1 year you'll have to. So certain is 1 year.
But even if it is for 1 year.
4.5.
Still then that financial viability.
4.5.
Stoppage of.
4.5. He says, keep it 4.5 as a barrier or a benchmark.
But what would be the appropriate barrier or what would be the appropriate benchmark? That is to be decided by the.
True, he says that you should decide it as 4.5, and then you can go to 9, no problem. Even you go higher up, give marks, no difficulty. But you are preventing somebody to participate who has 4.5 turnover or may have 6 crore turnover, but is deprived because you have fixed at 9 crore.
Now he is claiming it should be 4.5. Previous tenders, it was reduced up to 6
From
crore.
6 to 3. In a corrigendum, in the meeting, you have reduced from 6 to 3, realizing that yes, there is a problem. That is what you showed.
In fact,
Can be cautious.
and attention, entire state of Odisha, nowhere such high turnover has ever been big, because the Krishna participates in a lot of tenders. Maximum they had gone to the last occasion, the same which I have given on affidavit and memo. They have gone to that extent. 6 crores fine. But beyond, because there is a guideline. Guideline says this is the parameter. Now, if you're functioning beyond that, you can't fix 20 crores, 25 crores for because these people have been running these tenders. The participants who are participating in these tenders, they have that kind of annual turnover according to the participation. So, what are you trying to do by fixing a higher?
And difficulty is that you are inviting such an intending bidder who have, I would say, obtained the tender or the contract in multiple places. If this is the fixed rate, then nobody would achieve more than 4.5 annual turnover.
With this rate, And 6 bidders have already participated.
That is what it says, that
But six
there are
bidders have
other
already
competent bidders. There are other competent bidders who have not been permitted or do not qualify to participate. Had it been reduced, they would have participated. This is what it is. Nothing more.
Only I have given that master merit.
Yes.
There are 2 more judgments of Michigan River and Balaji Ventures. Including this judgment, the lordship.
Michigan says, I'm not relying upon, but Michigan says that where a particular clause is tailor-made, the court should interfere. The paragraph in there.
Everything boils down to that arbitrariness or
Yes.
not following their own principles.
Even media development authority, those decisions where they say ki, where there is a favor is being
It is a
given.
public interest only. Even that marine also, the public interest.
This is what I just
In the morning.
in the morning, Balaji, I have considered.
There are also Michigan works.
Considered. Yes. Good. See you. See you. Donation has been done.
So there is a delay of 262 days. And
Service.
copy of the application.
The,
Sir.
what object? Serve the copy.
And sir,
In course of this day or
in this day.
this is the matter on Thursday. Service. No. You want after vacation? Okay. Perfect.
Item number 6.
After.
Item 6, my lord. Here there is a delay. I'm
The-
also having a copy of the character.
Why you don't, why you people do not serve immediately after the filing or before the filing? Can we fix on Thursday? It's Thursday.
Item number 7.
Copy is served today. Who? We'll see to it. Definitely, it's of a national importance, so keep it when he's available.
On Monday or Tuesday.
Next Thursday.
Item number 8.
So I completed the work since.
Counter file,
Yes, Your Lordship.
Copy has been served with us. Looks like completed.
no rejoinder.
Plus the counter at para 11 they admit that to my entertainment.
Yes,
My prayer is.
yes, why you are not paying, madam?
Your Lordship, his
6 years.
29th RA bill has been paid, Your Lordship, on 26/6/2025. And as per clause 31, he has not raised his escalation bills, Your Lordship. So that has, it is not there with the authorities till today.
So why you have not raised?
Please come to clause 7 at pace.
Sir, maybe your entitlement is there, but what they say is that they do not find any escalation bill to have been submitted by you. If you do not submit the bill, how they will consider those bills and take a decision?
Limited to the escalation bill. I am not an escalation bill.
So other bills they have already paid.
No.
They say
Finally, Your Lordship, as per OPW code, it will be paid, Your Lordship.
It will
If
be
there
paid.
is
6
will
years.
be paid or wait,
change of government, Your
will
Lordship.
be paid or have been paid.
29th RA bill has been paid on 26/6/2025.
That is
Your
paid.
Lordship.
How many RA bills are pending?
All has been paid.
High bills are paid, final bill is pending.
And escalation bill, Your Lordship, he should have, every quarterly, he should have submitted the, during the course of the work, he should have submitted the vouchers and claim. He has not done that.
The final bill is the escalation bill.
No, Your Lordship.
Final bill is the residue amount.
Residue amount.
All RA bills are interim payments. Final bill is the residual amount. That will be prepared by them as per clause 7. They have not done this as on today. They have not done that. They are saying, admitting that I will pay, and no the decision as to when they will pay. 6 years have gone down from my completion of work.
And he was asked for a joint marking and of the.
Where is clause 7?
Let's may come to page number 828 villas. 28 PDF page 31.
No, bring. Where?
Clause 7. The final bill has it.
Okay.
The final bill shall be prepared by the Office of the Rural Works Department in accordance with the rules of the department in the presence of the contractor within 1 month of the date fixed for completion of the work. So the completion is in 2019. As on today,
It is you who have to prepare it.
Yes.
Yes, Your Lordship. He had not given his RA bills.
Have you communicate? RA bill has been submitted.
Paid. Now it has been paid, Your
So-
Lordship, in the month of June.
Of the.
And they're preparing the fact.
What they have said. Yeah.
Let's say, which is the obligation of the contractor to submit the escalation bill quarterly with contemporary.
Not concerned with final bill. Plus 6 is Millers में 6 में भी para 2 of 6 Millers. Page 28 last 4 lines Millers. First 4 lines, I'm sorry. If the contractor, Millers I'm reading, Millers has it, page 27 last 2 lines Millers.
Yes.
If the contractor does not submit the bill within the time fixed as aforesaid, the engineer in charge or his subordinate shall measure of the said work in the presence of the contractor whose counter signature of the measurement list will sufficient warrant, and engineer in charge or his subordinate shall prepare from such list which shall be binding on the contractor in all aspects. So, Millers, as on today, if I do not, they are saying I have not given. It is not final bill. I do not have to give. Only RA bills I have to give it as per this clause, Millers. So RA bill is paid. Final bill has to
pay para 16. We have answered that, Your Lordship.
What?
Para 16 of a counter affidavit.
Yes, what you have said?
We have said that the subordinate staffs of the opposite party number 3 measured the works because the contractor didn't come, Your Lordship. That is stated in para 15. And the works executed at site as on 11/9/19 and submitted the bills to the tune of 55,98,215 and net payable amount of 50 lakhs 23,518 after admissible deductions.
Correct.
The opposite party number 3 endorsed the said amount as payable under 29th RA bill.
Correct.
But the contractor did not comply his part of obligation under clause 6 of the agreement. And
What clause 6 is?
that he should have prepared the bill and presented.
No, he says that, please, a bill shall be, I am looking at clause 6.
Yes.
Bill shall be submitted by the contractor each month on or before the date fixed by the such and such, or a subordinate shall take a requisite measurement for the purpose of having the same verified. Just
Yes, Your Lordship.
having the same verified,
And
where it is.
as far as admissible, adjusted, if
Huh.
possible, before
Before
the
the-
expiry, often expiry of 10 days, from the representation of the
Bill.
Bill.
If the contractor does not sell bill such and such, the engineer in charge shall measure up the said
Yes,
work
of course.
in presence and then will prepare a bill, such list which will be binding on the contractor.
Yes, Your Lordship.
So-
that is prepared.
So 6 and 7 read together, we get the perception that he did not have to raise any final bill.
No, that it was measured.
Where is that final bill? Where,
That-
where is the provision for final bill? You see, you have to measure and you have to
We
finalize.
did that, Your Lordship, and it came to the net payable amount of 50 lakhs 23,580.
Where is
That has
requirement
been
of,
paid.
Oh,
there is requirement
madam,
of
madam,
raising final bill.
he is raising a RA bill.
Yes, Your Lordship.
He has submitted to you. Now you can make a measurement. Whatever is required, you have not done. You have seen the RA bill and you say the statutory deductions are to be made. You are required to be paid only 50 lakhs rupees out of 55. They are paid. Now, a final bill has to be prepared. Who can prepare the final bill? It's you.
Yes, Your Lordship.
You should say in the final bill that now, after this entire measurement which has been undertaken by our office, now we find that the only amount which is required to be paid to you is 5 rupees. Will you not make that final bill?
Your Lordship, that we
Your
have
para
measured the work.
17, your para 17 is
16
misconceived. Your para 17 is misconceived. Similarly, no final bill has been raised by the contractor.
How
Where
can
is
you
the
raise a
question?
final bill? It is you who have to prepare a final bill.
Your Lordship, that they have measured whatever work he has
Have
done.
you raised the final bill?
And yes, Your Lordship. And
Where is the final
the
bill?
net payable, they said that submitted as on site and submitted the bills for the 5.
If you say so, then what about para 17, this line?
That there was no bill submitted from his
Can
own.
he,
Yes.
final bill, will he, clause 7, come to
Your
clause 7?
Lordship, clause 6 says bill shall be submitted
Please,
by the contractor when he.
please, come to clause 7. We are talking about final bill. Clause 7, read
Yes, Your Lordship.
what it says.
It will be prepared, the final bill shall be prepared by the office
So-
of the Rural Works Department.
So,
After measuring, that they did, Your Lordship.
have you, then why you have said that since he has not submitted the final bill, so we have not made the payment, paragraph 17 of your counter?
No, the final bill, it has been said in 16 that after deduction.
Sir,
whatever was
sir,
paid to him has been
have
paid.
you took a stand that he has raised all the bill and after the measurement, the authorities have found it to be a final bill and then he is entitled to a payment. We could understand your stand.
Your Lordship may give me 1 week time, I'll file an additional affidavit to that effect.
What?
Lordship. It's get it clarified from the department.
Nothing clarified. Your
It's-
stand,
it's-
you cannot prevaricate your stand every time. When you prepare the affidavit, you should be well aware that what is required to be met. That's the whole irony I find. In a more hurried manner, the affidavits are filed. In a cavalier manner, it is filed without application of mind. And whenever the certain questions are put, I am filing an additional affidavit. If on that day some more questions are put, I am again filing an additional. Is this a way the system should work?
No.
You know, he has raised that objection.
Para 6 never says that. Your
Para
para
6 says
17
the
is
bill shall be submitted by the contractor each month on or before the date fixed by the engineering judge or his
Sir,
subordinate.
there are contingencies that if he does not submit the bill, then there will be a measurement taken by him for the purpose of payment.
Yes, we have taken.
Sir, he has submitted a bill. There was no question of any measurement to be taken. Look at paragraph 6, clause 6.
Your Lordship, we have measured. Lordship may see para 15.
you have measured, but settlement of finality is with you.
Your Lordship may see para
Clause
15.
6.
Para
Clause
15, Your Lordship, for a moment. That
Yes.
they have, it is humbly
Now
submitted
I will
that
be,
it is absolutely
now when you are taking us, I will be very critical. I will be very critical on your affidavit.
petitioner submits
Yes.
the 29th RA.
You can't
Yes.
in two paragraph
Fact,
contradict
work was-
yourself.
Yes, Your Lordship.
You can't contradict yourself in 2 paragraphs, which is contrary to clause 6 itself.
He had not submitted his 29th RA bill, Your Lordship. They took the measurement, they found that he had done the work of 50 lakhs, 23,518, and they paid the same. And there is escalation, as per escalation, that is clause 31 governs it. And he has not in quarterly terms, he had not submitted vouchers and raised a bill for the escalation. Except steel, cement and labor escalation.
Kindly explain where from clause 6 we can get support of your paragraph 17.
No, Your Lordship. In clause 6, we have said that, in 16, we have said that your Lordship can see page 15 para. As a matter of fact, the work was completed on 31/12/2019.
I am on 17. You have paid,
15, Your Lordship.
you said 29th RA bill is paid.
Was not submitted by the petitioner, contractor in pursuant to clause 6. As the contractor did not submit the bill in time, the opposite party number 3 bona fidely instructed its subordinate staffs to measure the works executed by the contractor in his presence. Then 16 paragraph we said the subordinate staff of the opposite party
This page and
measured the
that
work
page.
and executed the site as on 11/9/19 and submitted the bills for the tune of 55,98,000 and net payable amount of 50,23,000, Your Lordship, 518 after admissible deductions. This opposite party number 3 endorsed the said amount as payable under 29th RA bill, but the contractor did not comply as part of obligation under 6 that they're saying that
What is that obligation?
that RA bill to raise the RA bill, he had not raised the RA bill.
Which RA bill?
29th, the one.
29th he has raised.
No, he has not.
Sir, the RA bill means what? The RA bills
Running
means
up.
when they are continuing with the construction. So the amount of construction which they have done,
Yes, Your
you will
Lordship.
make a measurement and will do it, just verification. But so far as the final bill is concerned, that you will have to make your final bill, that when he completed the entire work, these are the 2 stages.
Yes, Your Lordship.
You are talking about, you are mingling up both the stages.
No, Your Lordship, we said the very first clause 6.
Very-
Pursuant to clause
Madam,
6, this is what
However,
It is.
however, as
Just
the
brother,
administrative approval
you-
has
you
been
need not-
accorded
you
on
need not
such,
have-
so the
Yes.
amount under 29th RA bill
Need
was
not have
promptly.
dictating me. Yes. We need not have. Stop. The
Yes, ma'am.
Your Lordship,
Or rural works.
If I may,
Division is a part of water department.
if I may, Your Lordship, clause 7 of the contract, Your Lordship, it's a writ petition.
There is
Seven
no
of the
provision of a post-mortem after the judgment is dictated and delivered in open court.
Number 9.
Hey, one-
Yes, but we have a public interest litigation, protect the general public with village of Gudurguni in the district of Balesa.
What is there? Have you initiated proceeding?
Yes, my lord. Previously, my lord, all those persons had, that place had been made encroachment free. But now they once again encroached and we have already initiated proceeding, my lord. And a date has been fixed, my lord, to the month of November.
Now I am asking you, there is one thing which I really wanted to know. Suppose a person have encroached upon the government lands. Under the act, as I find OPLE Act is there, you are supposed to initiate a proceeding when a person is found, that's my impression, please correct me, I am not saying, is found to be in settled possession, means his possession is for a longer period. Now you wanted to evict them. A opportunity has to be given. But a person trespassed recently, say 1 day or 4 day or 5 day before, after they were removed, will you still go for those, or you can summarily remove them?
My lord, it can, my lord, the procedure.
It is, I'm just asking somebody, I'm just giving an example. I have gone to attend some ceremonial or social function somewhere out where somebody enters in my house, trespass, and then say that you file a suit, get an eviction degree. Is it permissible? Just a momentary possession or trespass, not in a settled position.
Has to be a summary procedure.
So I'm just thinking, I'm not saying I have not seen the law, I have not seen the act, but I'm thinking aloud in this way that every time somebody will come, now the proceeding will take near about 7 years, 10 years to be decided. What is this?
My lord, the procedure prescribed under the OPLA Act, that is a summary procedure, my lord. It does not take that long, my lord. We are required to give them in nature of a show cause notice.
Whom? Those who are in settled possession, found to have been in possession or trespass for a considerable period of time. Then they are now settled. I can understand. But just an act of trespass, 1 day or 2 days before, what?
But in this case, my lord, they have again once.
That is what for that reason I asked, that you initiated a proceeding, you gave them an opportunity of hearing, ultimately passed an order, you evicted them or you removed them from the government property. Now they have again come. That means of a recent origin after that order. How long will it continue?
Now, my lord, they start cultivating that land once again. So, my lord, it can be termed as, my lord.
You are allowing them.
Allowing.
So, my lord, we have initiated again, my lord. We have.
No, initiate again. Why? That is what.
That's what
my lord.
This is correct in that sense.
So there should be something. And it is the same gentleman who has done. So take instruction and come back 1 week after vacation.
Number 12.
May I please, your lord?
In item number 12, we are for the Union of India and the copy has not been served upon them. We are for the Union of India Railways. The copies
Who is for the 12?
I am for the petitioner.
Sir, why you do not serve the copy on the Union of India, sir? He is coming and making these submissions that I have not been served with a copy.
I apologize for that. My associate either he will solve it.
There is no associate, sir. Why don't you serve? Where is the service? Yes, sir. Serve next Thursday.
You are appearing for 3 and 4. Mr. Rath, you are appearing for 3 and 4.
Item 13.
I don't know, I think, may I please ask? But after filing of the writ application, some development are made by the opposite party. Here the prayer of the solution is that which a class contractor is total and his job and thereafter he has been blacklisted in the. So what instruction I have, the chief engineer will already directed the chief engineer procurement cell to remove the blacklist mirror. But the
So that has become infructuous then. You are challenging that blacklisting order.
yes, ma'am. Look, who amendment I want to bring the said fact in my repetition.
What? Then it will become infructuous. Then there remain nothing in the writ.
Only at a criminal, only one direction from this one can resolve my issue. Not can have a grant to the instruction mirror
What?
given by the chief engineer procurement cell.
Yes, that if a high court pass an order, I will do it.
No.
So
Then the liberty may be entered to me by within this writ application. I can challenge the order passed by the chief engineer.
it is up to you. Why we will say so?
Yes,
It is your wisdom whether to continue or not to continue.
Yes.
What?
I will withdraw this writ
File your memo, withdrawal. That's all. Why don't we make our position?
Samson, you effectively the chief engineer procurement cell has no power to deny the directions given by the chief engineer who called the tender.
If you want to argue, you argue the matter. If you want to withdraw the matter. It is up to you.
Permitted me to
Withdraw.
Item 14.
Please, Your Lordship. Lordship, I appear on behalf of the petitioner. Your Lordship, kind indulgence is very much warranted in the present case. Your Lordship, may kindly appreciate the respondent number 3 had floated a tender for supply and commissioning of growth monitoring devices. My Lord, I submitted my bid along with the necessary documents and annexures. My Lord, the certain clarifications were sought by the Technical Evaluation Committee. Those were duly clarified. My Lord, on 23rd of August 2025, they have rejected my technical bid on arbitrary, unreasonable, and discriminatory grounds that I don't meet the experience criteria. My Lord, kindly appreciate I am a reputed manufacturer based in Delhi. And my Lord, I have been supplying and providing services to the respondents and to various state departments across India for the past 20 years. And my Lord, there is not even a single evidence against me wherein I have been blacklisted or debarred. My Lord, please, my Lord.
No, they have disqualified you on what ground? Where is the ground? Show
My
us.
Lord, may kindly have page number 56 of my petition. 53 of the petition, my Lord. My Lord, the first reason cited is that experience criteria not met.
Yes.
My Lord, this is a vague submission and reasoning that has been recorded by the Technical Evaluation Committee because they do not specify as to what is the criteria in which I have not met the stipulated terms. My Lord, secondly, there is this reasoning.
So they have given a reason.
Please,
what
my
is
Lord.
the experience criteria and what you have given?
My Lord, we have duly supplied documents and submitted documents.
No, the document with no only thing is the subjective satisfaction from the document. You may give 100 documents, but those are not relatable to your experience or
Lord,
a particular experience which they want.
My Lord, I'll satisfy your lordships.
Show us that what is the experience criteria and show us.
My Lord, the experience criteria is on page number 19. Of
19.
Please, my Lord. My Lord, clause number 2. In respect of the filter applied for the experience criteria, the bidder or its OEM of the product offered in the bid should have regularly manufactured and supplied same or similar category products to any central state government organizations / PSUs for a number of financial years as indicated above in the bid document. Copies of relevant contracts and delivery acceptance certificates to be submitted along with bid in support of having supplied some quantity during each of the financial year. Now, your lordships may kindly have my written representation that I had addressed to the technical evaluation committee and to the respondents.
Yes.
My lord, along with this written representation, I have
Where is
enclosed.
the representation?
My lord, it is annexure 7 at page number 56.
Yes.
My lord, along with this written representation, I had
Sir,
enclosed.
this is what you have written representation after the rejection.
Please, my lord.
There is nothing which is said that you have an experience. Let us go.
My lord,
Your entire representation is restricted to the second ground.
please, my lord. My lord,
Where is the ground for experience?
My lord, because my lord, clarifications were sought, which were duly clarified. My lord, may kindly have page number 76 of my petition. My lord, these are the contract order copies which were submitted before the respondents, wherein we satisfied them that we have supplied the equipments in the past 3 years. My lord, may kindly have page number 76. My lord, we have supplied equipment to the Women and Child Department, Haryana.
Page
76, my lord.
Yes.
My lord, may kindly appreciate, my lord, this is a contract order copy dated 16th of August 2024. My lord, in the item description table, my lord will find the equipments that we have supplied in the year 2024. My lord, we have supplied infantometers, we have supplied stadiometers, we have supplied the mechanical weighing scale infants and the digital weighing scales. My lord, this is with respect to the.
What is your response?
Lordship, notice has to go Odisha's medical.
Notice. Returnable on you submit today. Anybody is representing?
1 and 3, Your Lordship. For the Odisha State Medical Corporation, Mr. Pravat Mudali, he generally appeals, Your Lordship.
No, 2, 4 and 5.
Right, notice has.
4 and 5 are also one Mumbai, one New Delhi. Private parties.
Issue notice on the opposite party number.
I'm grateful, Your Lordship.
Selection of opposite party number 5, who has not fulfilled the criteria prescribed under the tender clause 6 of the tender document. And the same has been supplied to the petitioner only on 1/9/2025 on the RTA Act. The Lordship may see the tender for notice. The relevant portion is page 16, it starts from 16, page 16.
Yes.
Next page 17 clause 6, man. The tenderer should submit the following documents.
Original document at the time of verification. Then duly signed.
In the tender.
Bank draft.
Tender paper duly signed it.
Yes, attested copy of the income tax return and the copy of the PAN card. And
Tender
GST
paper duly signed by the tenderer, token of acceptance, terms and conditions tender. Bank draft, attested copy of the valid registration certificate under
Oh,
common
I
carrier
see.
order.
Then what you say? Which one
But
has
he
not been?
He has not signed the tender.
He has not signed the
No,
tender. Oh,
he-
wonderful.
Not attested the copies of the income tax return as well as the carrier certificate.
No.
And also, and then the next page 18 plus 7, my lord. Certificate from any government organization about past experience and performance of the tender or
Issue notice, let him come and respond and produce the entire his tender document.
I have obtained the RTI and I have obtained an annex, my lord.
So whatever.
All the tender documents submitted by that opposite party of 5 million.
Yes. Issue notice, come back 1 week after vacation. Anyhow, yes.
Item 16.
Then I
No.
object to
No.
authorize they will.
No, let them.
Let
Let them. Let's see to it. No.
16.
Sought clearly, the state in its wisdom has readjusted the NDQ, which is the leasehold obligation, also ruled that it's a lease of sand quarry of lease.
Correct.
But lessee is bound by NDQ, which is a consequence of Rule 36, and agreement also provides that this was.
What is this? What do you say?
Minimum guaranteed quantity.
MGQ.
Right.
Okay.
Minimum guaranteed quantity of sand.
Correct.
That is a consequence of Rule 36.
Correct.
And also agreement provides that successful bidder has to leave this quantity of sand every year. That is also approved in the mining. That quantity is in the agreement. Now, what happened? This source was settled in the year 2021. Now, after settlement of the source, it was locked up in different litigations. 3-4 PILs, 1 NGT proceeding. So, lessee could not operate it. That's the positive finding even they have considered it. Now, as a result thereof, the MGQ has a direct connection with payment. Unless I lift it, I have to pay for that. So I applied the authority that look, this is the difficulty. I cannot be compelled to perform an impossible act. Since mines remain closed on account of different interventions, you kindly readjust the MGQ and proportionately adjust the money. They have done it. They are kind enough to readjust the MGQ. That your lordship will find page 66.
Then what is the problem?
Only problem is the proportionate payments to be indicated in my site so that I can adjust it. That's all. So they can take instruction on this.
I'll take instruction.
Thursday? Small one.
I'll take instruction.
Take instruction and come on Thursday.
Thursday.
That is what I'm saying.
Yes, sir.
So that you can dispose of on them.
Right.
Yes. On Thursday.
Seeking instruction Thursday.
17.
Petitioner is challenging the annexure code with the demand notice, the OP number 2 issued to the present petitioner at page number 16. The entire, if your lordship will go through the demand notice, your lordships, no provision has been assigned under which the calculation and the penalty and royalty has been given to the present petitioner. It is purported the notice itself so that, my lord, on the basis of a RI report on which neither the petitioner has been present nor he has been allowed to be, my lord, has been given any notice. And I am a, my lord, small supplier of sand and moram. I was, my lord, my material was seized without giving any seizure list. Thereafter, I have given all kind of Y funds, which has also been admitted by the authorities without considering those.
Sir, these are the cases where they say that illegal storing of the sand and the moram.
Well,
did you have any license or a lease being granted to you for such?
My lord, yes. Your lordship may see the letter in the notice itself.
Yes.
My lord, last 4 lines.
Yes.
The documents you have provided to the competent authority on dated 13/8/2025. These documents at annexure 1. It is the, my lord, Y forms which are necessary as per the, my lord, OMM's rules to, my lord,
Yes.
My lord, the sand and morals of my story, I have also produced those documents, which has been completely discarded, and he has raised
What discarded? It says that it does not, is not an eligible one.
without giving and the
Should be,
and the demand is, my lord, 26 lakh.
it says that it is not eligible. What more? What is that document? For storing of the sand and mora? Where is that document which you submitted?
My lord, those Y forms on which, my lord, I was,
Where is that?
those have been, my lord, received by the authorities without,
Where you have done? Have you got a photocopy? Have you annexed those copy?
my lord, at page number 3, your lordship, my explanation, after giving a public notice, I have annexure 3 is my lord, letter to the.
Sir, I wanted to know this document which they have said is
My lord,
makes you ineligible and it is not sufficient for storing the minor mineral.
that has not been given to us, and we have also,
Even to us, then you have submitted, sir.
my lord, submitted that they have admitting. They have admitted,
Can we not look at that document?
my lord, that is the unfortunate part, that he has not kept the originals. He has the
Do you have that document?
What my learned senior is saying, Form Y. Form Ys are meant for transportation, for dispatch of mineral from one place to another, not for storage. So, my lord, he says that.
Please show us that.
My lord,
Form Y is only, where do I get it? It is only for transportation.
My lords will see, my lords, Rule 58.1, my lords. Rule 58.1. 2016 rules. 58.1, my lords.
Yes.
That's no holder of prospecting license, come mining lease, or mining lease or quarry lease or quarry permit, or auction purchaser shall dispatch any minerals from any area without a valid transit pass in
And
Form
where
Y.
is the provision for storing and all?
My lord, Form Y, my lord, there is no
From Y is only for the purpose of transit. It is a transit pass.
My lord.
Is a transit pass.
No.
I understand. Storing and for that, what is the permission?
My lord, I went through the rules yesterday night to the best of my. I did not find any provision, my lord, where storage has been mentioned, at least not under these rules.
So under what?
My lord,
If he has been granted a mining lease, if he is there, then where is the difficult? Where he will do it?
Lord,
Extraction and then storing cannot be
my
done.
lord, the storing can be done in the area where it's permitted to extract. But my lord, if it transports and stores in some different area, which does not belong or where.
Please show us that it was at the different area.
My lord, my lords may see the notice.
Oh, khata number.
My lord.
Plot number such and such, which is not.
Yes, my lord. So those areas, my lord, they are not.
So where they will get the extraction does not mean that the extraction has to be done or the transport has to be made.
My lord, it says different plots over Moja so and so on the river embankment of their river. So my lord, on public property, my lord, those things have been stacked.
So you can remove those articles that you cannot stack on the public land or a government land. I can understand that. I'm just asking, a person is given these to do a mining activities. He is doing a mining activities. He has to keep the materials which he has extracted or mined. Where he will keep? Selling is not that everybody is just eyeing. It is coming out and then sold. No. It has to be stored somewhere and then the transit. Without the transit pass, he cannot sell those. Then?
Well, he has the transit passes, so he can remove them from the place from where he has extracted.
So he says that I have removed, but you are saying that is storing.
Well, storing. In some.
Wow, where is the permission?
Well, that my lord permitted to take instructions.
Take instruction, come on Tuesday.
Wednesday.
Wednesday. Come on Wednesday.
interim.
What?
Interim.
The rejection will come if they come and show us. If they come and show us that you cannot, then the rejection will come.
Yeah, so we can demand, that is what we got. Compounding provision is also there.
Look at it. It is a Wednesday. Let him come.
Item 18.
Lordships, my lord. I am on BC minor.
Written in connected matter,
Yes.
Case to instruction, the first time case.
Huh.
As alleged in the tender, we have favored to some of our own man and we have not adhered to the principle.
Yes.
Yes, my lord.
Come
Yes,
on
my lord.
Tuesday. Take instruction and come on Tuesday.
Obliged, man.
Tuesday.
Item 19.
Please, Your Lordship. Second intercall notice under Annexure 8 at page 27 is under challenge. On the ground that so far as earlier tender notice under Annexure 3 is concerned, the petition.
You are challenging the tender process itself.
The tender process manner.
Yes, show me the notice. Where is that e-procurement notice with a bid identification number ITDA? Where is that?
That is under Annexure 8 at page
8.
27.
Yes.
Your Lordship, got it.
Hmm.
My Lord, so far as first tender call notice is concerned, the petitioner had participated in respect of serial number 3, 4, 17, 18 and 28 works. That is construction of additional classrooms.
No, I understand. The 3,
4,
4. Yes.
17, 18.
17, yes. 18.
16, 17 and 28. I'm sorry.
16, 17 and
3, 4, 16,
correct.
17 and
So it is all in relation to a construction of an additional classroom anyhow in a different place. No doubt.
I am a lowest bidder and I had expected that I shall be called for.
Then why the first tender call notice was not processed?
Therefore, I made an application before the collector. That is under Annexure 4 at page 23. Made a representation.
Sir, you are L1 in the first tender call notice, correct? Now that tender was cancelled or rejected or what?
That was not communicated to me, my lord. Without assigning.
Now you say it's a second tender call notice. That's why I'm asking.
My lord. Whenever I came to know that the second tender call notice was floated, I wanted to know the reasons for cancellation of a first tender, filing RTI application before the authority concerned, which I have appended to this writ petition matter.
So what is the information furnished to you?
No information has been given to me.
What has happened to first? Cancelled?
It come on Tuesday and take instruction.
Come on Tuesday.
Item number 20.
Last day receipt of
22nd of September. 22nd. You come on 22nd.
No, 22nd.
Right. Item 20.
Stay, madam. Tender process may be stayed. Pursuant to secretary tender call notice.
Very difficult.
It will come on Monday.
22nd, yes. Come on Monday, you take instruction. In the meantime.
Item 20.
This is a contempt application.
Contempt application?
Yes. That your lordship.
Whose order is violated?
Your lordship, sir.
Your lordship, first order for consideration of the volume.
First order was?
Page 61. The operative last but one per. Page number 8. The start with page number 8. So annexure 1. You also will come to page 61. That is the operative question. It is therefore directed that the appointing authorities have considered the representation of the notice dated 24/6/2024 submitted by appellant to the respondent opposite party number 1, Commissions of Secretary Health Department within a period of 2 weeks, keeping in view the health issue has highlighted. It will also come to the conclusion part at page 60. Because you have decided the matter and
Where?
page para 10, page 60, conclusion. Given the above factual matrix and circumstances and constitutes training sets of.
I am unable to reach.
Sorry. Page 60.
Yes.
10 of your system.
Yes.
Para 10, you are saying the
Yes.
Given the means of legal position, this court having perceived infirmity and irregularity as discussed supra is inclined to show indulgence in the judgment of 2025 rendered in WPC number so and so. The region ascribed supra and in the light of the discussion made in the foregoing paragraph, as the consequence thereof, the judgment dated 14/12/2025 rendered in WPC number 2792/2024 impugned hearing is set aside, and thereby the decision of the committee communicated by the Commissioner Secretary Health and
Is also cause.
Is cause.
Is not in consonance with Rule 42.
Rule 42 of the Orissa Civil Service.
Consider.
And to directed the committee number 1 to consider within a period of 2 weeks hence. That means she passed the judgment on 8/7/2025. 2 weeks expired on 22/7/2025. Now 2 months expired. By 8 weeks have already expired. They have not taken any decision. So,
as a first point, I will take instruction. But I am talking to them, I found they were saying that initial rejection is reason for initial rejection. Doctors are found nowadays, so we are not able to accept his resignation. That is it.
That has been discussed by us.
Let it come on Tuesday also, man.
Is a contempt, sir.
For consideration, my lord,
You should remember it is a contempt.
Let notice go to them.
Yes, notice 1 week after.
Make a Item 21.
So like the one is consolidated of multiple years. And I will not provide 1, 2, and 3.
Give separately for all matter.
Others, sub-item 2 to 6, 17, 40 of finances.
Yes.
And made the necessary corrections.
Yes.
Item 22.
I'm not consulted all of for multiple years.
Next.
Item 23.
By the jurisdictional assessing officer instead of regular assessing officer. Similar matter in
We are checking instruction to file.
Yes. Next.
You want to verify it? You want to verify it?
We have to file counters. Then we have to, it has been fixed.
What is the position that?
We should fix this matter along with that matter.
Yeah.
It's a long term. There is matter on. Yes, call.
Item 24.
Yes.
The cancellation matter, it is covered under your losses order dated.
If. We put the other side. Yes. Next.
Item 25.
Describe a similar 23. 25 is similar to 23 relating to the spaceless assessment.
Okay.
These are the three correct.
Yes.
Item 26.
26 years. The last one is description. See the matter recalculating your losses whoever insists one contractor. They are executed a work of 4,80,000. What certificate was issued? As per the contract, the warranty period is 1 year. But after 2 years, when the form was available for the officers to be released the form, he immediately issued the letter that some verification is required. That is why the
Can you do it after 2 years when the warranty period is of 1 year? Can you issue a letter saying that there is a defect when the warranty period is of 1 year? He can repair it, you pay the cost. Pay the cost.
Your Lordship, last time AG admitted matter, not in AG, and your Lordship asked the DA, them to, if admitted dues, it will be paid. If it is admitted, then the dues you are to pay, they were to pay. Let it come Tuesday, I will take it.
last time, though it is not.
Tuesday, let it come, I will telephone them and see. If they are admitted to pay, why they will not pay? Come on Tuesday.
Tuesday.
Item 27.
Have you served?
Yes.
Who is appearing? Have you got the copy?
Lordship, I am having only one copy with me. There are 4 petitions, similar and common.
So-
Common.
Please pay.
I have.
Serve the copy on all.
I'm already.
You are representing whom?
Income certificate.
Correct. So who are the opposite parties or respondents?
Only one respondent.
So you are served with a copy. Only one respondent.
Hello.
So you say 4 respondents.
No. 4 similar matter, 4 matters are there.
They are
common.
kind of matters, sir. First, we have to take up first matter. If you want to conduct the case,
What do you say? There is a delay of 60 days.
Yes.
What is the ground? What?
Old record. Paragraph
Old record. And you are pursuing the remedy and old record. You have gone to the tribunal and from tribunal you are coming. You have been traveling everywhere. Old record. What? So how you defended there before the assessing officer? How you defended before the appellate authority of the appellate forum? How you defended in this is the income tax? Yes. How you defended in the tribunal? ITAT?
And the collector is hearing. So there is.
Bank means what?
Yes, cooperatives, central cooperatives, right? Balisur Bhadrak Central Cooperative, it's the one in the state. It's a huge deal, that effect and the procedural.
160 days.
160 or 60?
60. 60.
60.
Man.
66. 66. Yes. Condoning. This is the application.
186 minus
120.
This is an application for condonation. This is an application for condonation of delay of 6 days. 6 days in preferably instant appeal beyond the period of limitation provided there. The appellant is the cooperative bank and is challenging the order of the income tax appellate tribunal. Dated 21/10/2024 on multiple counts enumerated in the you have filed a memorandum in the memorandum of appeal. So it is averred in the instant petition that since the procedures are required to be followed after taking opinion from the different officials, it causes a delay in filing the instant appeal. So apart from the same, it is averred that the person who was entrusted to take steps for filing the instant appeal also fell ill and could not contact the learned advocate promptly, and immediately after the recovery from the illness, the contact was made to the learned advocate, who consumed some time to prepare the appeal, and therefore the delay caused in preferring the instant appeal is unintentional, and no negligence can be attributed to the conduct of the appellant. Considering the aforesaid submissions and the amendments from the petition, we find that the explanation offered is satisfactory and constitute a sufficient cause for the purpose of condonation of delay. Accordingly, application being IA number such and such is allowed. The delay in filing the instant appeal is condoned. Appeal to be listed for admission after vacation. Immediately after. Yes.
Item 28.
One common order.
Two.
Separate years.
Have you filed your IA for condonation?
No, I'm separate.
See,
List.
Item 28.
28 and 48. 5 years, more than 5 years delay.
file your objection. Opposition.
Let them submit.
Delay of 398 days.
No, of course.
Give,
when you look at
give
the
the copy.
You see where it is disposed of. I see it was disposed of on.
The application for condonation.
Yes, ma'am.
Then there only.
Disposed of? No.
No, not disposed of.
Then-
The application was disposed of. What
Oh, that is what is there, but there is a delay. You have filed an application for delay. How many days delay?
Including the interest, I don't know.
398, so more than 1 year.
More than one.
Yes, then he is entitled. Stop. These liberty.
They should pray for a correction, maybe oral prayer. In the limitation petition, they have committed a mistake, writing 1839 days delay. They should correct it.
That is a mistake.
No, registry has pointed out.
Oh, we will go by the register. Don't worry. Yes.
Item 29.
29, my lord, I am appearing through VC, my lord. My lord, this is what has happened, my lord, in this writ appeal, we are challenging the order dated 3.
Where is the certified copy of the order?
Yes, lordship. Certified copy, my lord, there.
When it is obtained?
Today only, as it is not sent via email, lordship. There's a technical error.
This is the photocopy. Where is the certified copy?
From online, it is a certified copy obtained from website of the High Court, your lordship. I've applied for the certified copy and it was.
How do I know when you have applied and when they have made it
Digital signature is present, your lordship.
Digital signature does not say that the date of application for certified copy.
I have the application.
Show us.
My lord.
What kind of there must be an endorsement. There must be an endorsement. Why it is not there?
It's mentioned. It was delivered to my mail.
Sir, you did not get it.
My lord,
I am thinking about section 12 of the Limitation Act.
E-filing.
My lord, can I?
E-application.
Yes, sir.
What is the date of the application?
Your lordship, 11/9/2025.
What is the date of the order?
3rd of September 2025.
3rd September.
Yes, sir.
3rd September.
We have two modes of getting certificate.
No. But there should be a reflection that application is filed on such and such and given on such and such.
During Corona period,
Yes.
we have not put in one.
Can I submit my lord?
CP generated, sir.
This seems to be
Separate sheet of option.
Why this matter is coming before us?
My lord, what has happened? My lord, can I submit, my lord?
We talk.
What is this? Paragraph 8? Who has passed this order? How a writ lies?
My lord, writ doesn't lies, my lord. What has
So
happened?
it was permitted to be withdrawn.
Yes, my lord.
Who filed the writ petition?
Yes, my lord. We are the opposite parties, my lord, in this case.
Serve the notice. Serve the notice.
My lord. My lord, much obliged.
Keep this matter on Thursday.
My lord, much obliged.
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 No.
My lord, can I just call one?
Just, sorry.
My lord.
Item 30.
Much obliged.
For the minister and for the president. Your senior.
He is on accommodation with us. Today he is on accommodation. He has traveled to Bombay for vacations. I let's permit or else I will direct.
No, this is up to you. If you start, then you'll have to finish. It's up to you.
I pray my lord should be taken on 9. He'll be back by 8. 9.
Well,